Rain pressed against the stone steps of the courthouse like a slow, deliberate accusation. Morning traffic moved past without urgency, unaware that something was already wrong. On the east side entrance, beneath a bronze seal worn smooth by decades of hands, a uniformed patrol officer stopped a woman before she reached the doors. She was black, mid-40s, dressed plainly in a charcoal coat, leather bag at her side, her posture straight but unremarkable. To anyone watching, she looked like another citizen late for court. The officer spoke first, his voice low but edged with authority. He asked her name. She answered calmly. He asked why she was there. She said she had a hearing. The answer seemed to irritate him. His gaze hardened, scanning her from head to toe, lingering on her shoes, her hair, the absence of any visible badge. He told her to step aside. She complied without protest, moving closer to the railing as people streamed past, some glancing, most not. The officer said there had been reports of suspicious activity near the building. He said protocol required cooperation. His hand rested near his belt, casual but intentional. The woman listened, eyes steady, hands visible. She explained again that she was due inside. She offered to show identification. He ignored the offer. Instead, he raised his voice just enough for others to hear. On your knees, he said. The words landed with a weight that cut through the rain. Nearby footsteps slowed. A young clerk hesitated at the top of the stairs. A delivery driver paused beside his cart. The woman did not move at first. Confusion crossed her face, followed by something quieter, more controlled. She asked him to repeat himself. He did, louder now, sharper, invoking safety, invoking compliance, invoking the law. That he told her to kneel on the wet stone, hands behind her head. For a brief moment, time seemed to stretch. The courthouse loomed above them, columns rising like witnesses who could not speak. Cameras were already out, phones lifted instinctively, not with outrage yet, but curiosity. The woman looked down at the steps, then back at the officer. She said nothing. Slowly, deliberately, she lowered herself to her knees, rain soaked through the fabric of her coat. The stone was cold. A murmur rippled through the small crowd that had formed. Someone whispered that this didn't look right. Someone else whispered that it was none of their business. The officer stepped back, satisfied, radio crackling softly at his shoulder. He asked if she understood why this was happening. She answered evenly that she did not. He took that as defiance. He reminded her where she was. He reminded her who he was. Each sentence was measured to diminish, to establish dominance without shouting. He warned her that failure to comply further would result in detention. Inside the building, court sessions were beginning. Judges took their seats. Attorneys shuffled papers. Justice moved forward, unaware that on its own steps, dignity was being stripped away in public view. The woman remained still, rain tracing lines down her face that looked too much like tears, though her expression did not break. A phone camera zoomed in. Another followed. Somewhere in the crowd, a live stream started. No one yet knew her name. No one yet knew why this moment would not disappear. All they saw was a woman kneeling outside a court of law, ordered there by a man convinced he was in control, and for now, he was. The officer circled her once, boots splashing lightly, narrating her supposed non-compliance for the record. He spoke into his radio, describing a situation that sounded nothing like what bystanders were seeing. He said she was uncooperative. He said she refused lawful orders. The crowd shifted uneasily, caught between the comfort of routine and the discomfort of truth. No supervisor appeared. No one intervened. The rain kept falling, steady, indifferent, as the courthouse doors stayed closed behind her. Above them, a security camera tilted slightly, capturing everything in silent high definition. The seal of justice gleamed behind glass. Balance, fairness, restraint. Outside, on the steps, those words felt distant, as the woman waited, kneeling, for whatever came next. Minutes passed, stretching thin with discomfort. The officer's confidence grew as no immediate challenge came. He asked her again why she was there, this time with a tone sharpened by performance, projecting authority outward to the watching phones. She answered the same way she had before, voice steady, giving only what was necessary. A hearing. This courthouse. This morning. Each answer seemed to confirm, in his mind, that she was testing him. He demanded identification again, then interrupted her as she reached for her bag, ordering her to keep her hands visible. She froze mid-motion, then slowly withdrew her hand, palms open. The crowd murmured. Someone suggested he let her stand. Another voice warned not to interfere. The officer chose the latter voice, the one that validated control. He told her she would remain where she was until backup arrived. A second patrol car rolled to the curb, lights off but presence unmistakable. Another officer stepped out, younger, eyes scanning the scene with uncertainty. He took in the kneeling woman, the wet steps, the phones, and hesitated. The first officer briefed him quickly, framing the moment as containment, as precaution. The younger officer nodded, though his jaw tightened. They asked her to state her name again for the record. She did. The younger officer repeated it into his radio. There was a pause, faint static, then nothing. He tried again. Still nothing. The first officer waved it off, blaming reception, blaming routine. He told the woman that failure to comply fully would escalate the situation. He emphasized consequences. Detention. Charges. Delays. Inside the courthouse, a clerk finally noticed the gathering outside and pressed her face to the glass. She saw the woman kneeling and frowned, confusion giving way to concern. She turned to tell a bailiff, who glanced once and shrugged. Security handled outside matters. Court was starting. Dockets waited. The machine did not slow. The officer asked if the woman understood her rights. It was a strange question, delivered without irony. She answered that she did. He smirked, mistaking composure for concession. He instructed her to remain silent, then continued to question her anyway, fishing for contradictions, for anything that would justify what was already happening. Rainwater pooled around her knees. Her breath fogged faintly in the cold air. She kept her gaze forward, not pleading, not provoking. That restraint unsettled him. He leaned closer, lowering his voice, telling her this could end quickly if she cooperated properly. The implication was clear. Submission was the price of dignity. A bystander stepped forward, a middle-aged man in a suit, and asked what law justified the order. The officer turned on him instantly, voice rising, warning him to step back. The man retreated, palms raised, apologetic. Phones captured the exchange. Comments scrolled faster on the live stream. Viewers debated, argued, chose sides without context, without patience. The younger officer shifted his weight, uncomfortable now. He asked quietly whether a supervisor had been notified. The first officer said he was the supervisor on scene. His tone ended the discussion. Authority, once claimed, resists inspection. Another call went out on the radio, this time answered. A dispatcher asked for clarification on the situation. The officer summarized again, carefully, omitting the kneeling order, emphasizing suspicion. The dispatcher acknowledged and said a sergeant was en route. The woman finally spoke more than a sentence. She asked, calmly, if she could stand. The officer refused. She asked if she was being detained. He said not yet. The contradiction hung in the air, obvious to anyone listening. The crowd grew quieter, the discomfort thickening. This was no longer curiosity. It was recognition. A courthouse employee slipped outside, phone pressed to her ear, whispering urgently. She looked at the woman, then at the officers, then back through the doors. Somewhere inside, a name appeared on a docket screen, highlighted, waiting. Time inside and time outside diverged. The officer instructed the woman to interlace her fingers behind her head. She complied, slowly, muscles tightening with strain. Rain ran down her sleeves. The image fixed itself in the minds of those watching: obedience without guilt, control without cause. The younger officer looked away. A black SUV pulled up at the curb, unmarked, windows tinted. It idled. No one noticed it yet. The officer continued, confident, narrating compliance, documenting authority. He did not see the clerk return with a bailiff. He did not see the bailiff stop short, eyes widening. He did not hear the name spoken urgently into a phone inside the building. The woman remained kneeling, silent now, as the rain eased slightly. The scene had tipped past misunderstanding into something heavier. Whatever this was, it was no longer routine. And it was about to be seen by the wrong people. The sergeant's estimated arrival time crackled over the radio, distant enough to feel like permission. The first officer relaxed his shoulders, certain the delay favored him. He reminded the crowd to keep moving, citing safety. No one moved. The phone stayed up. The younger officer cleared his throat and asked again, softer, whether she wanted medical attention for the cold. The first officer shot him a look. The question died. A woman in the crowd whispered that this was outside a courthouse, that judges walked these steps every day. Someone else answered that it didn't matter who walked where. Rules were rules. The argument fizzled without resolution, mirroring the larger one unfolding in silence. The bailiff approached the glass doors again, speaking urgently to someone unseen. A security supervisor appeared behind him, peering out, then pulling back. Procedures tangled with pride. Nobody wanted to overstep. Nobody wanted to be wrong. The officer finally asked the woman if she had anything to declare before he proceeded. She lifted her eyes to him for the first time since kneeling. There was no anger there. Only patience. She said she had nothing to declare at this moment. He interpreted the words as evasion. He told her that choice would have consequences. The unmarked SUV shut off its engine. A door opened quietly. Still, the officer did not look. His focus was fixed on the woman, on the narrative he was building, on the certainty that control, once asserted long enough, becomes truth. The rain slowed to a mist. The courthouse clock struck the hour. Inside, a courtroom waited for a judge who had not yet arrived. Outside, the steps held their breath. 30 seconds later, the balance shifted invisibly, as systems began to notice a problem they could no longer ignore. The silence before recognition stretched, brittle, awaiting a name. And proof. The sergeant arrived without sirens, parking just beyond the crowd. He stepped out slowly, scanning faces before fixing on the kneeling woman. The first officer straightened, posture sharpening into formality. He began explaining immediately, voice confident, rehearsed, framing events as preventive, necessary, justified. Suspicious behavior. Refusal to comply. Safety concerns near a government building. The sergeant listened without interrupting, eyes moving between the officer, the woman, and the phone still recording. He asked why she was kneeling. The officer answered that she had been ordered to for officer safety. The sergeant asked what specific threat she posed. The officer hesitated, then cited uncertainty. The answer landed poorly. He turned to the woman and asked if she could stand. Before she could respond, the first officer interjected, insisting the situation was still active. The sergeant raised a hand, silencing him. He told the woman she could stand. She rose carefully, stiffness evident, water dripping from her coat. The crowd exhaled as one. The sergeant asked for her identification. She produced it calmly, handing over a small leather folder. The first officer leaned in, watching closely. The sergeant glanced at the card, then looked again. His expression changed, not dramatically, but enough. He checked the name against his radio, voice low. The response came quickly this time. The first officer noticed the shift and pressed forward, asserting procedural violations, trying to regain narrative control. He said she had been uncooperative. The sergeant asked for specifics. The officer listed orders. Kneeling. Hands behind head. Silence. The sergeant's jaw tightened. He asked whether she had resisted arrest. The officer said no. Whether she had attempted to flee. No. Whether she had posed a visible threat. No. The questions built a quiet indictment. Phones zoomed closer. The younger officer watched the exchange, relief and dread mixing in his face. The sergeant asked the woman if she wished to say anything. She declined, eyes steady, trusting the process now unfolding. The sergeant turned back to the first officer and asked why a supervisor had not been requested sooner. The officer said he was handling it. The sergeant asked why courthouse security had not been consulted. The officer said it was unnecessary. Each answer stripped away justification, leaving only authority exercised for its own sake. Inside the building, doors opened. A court administrator stepped out, pale, whispering urgently into a phone. A bailiff followed, then another. The unmarked SUV's other door opened, and a man in a dark suit stepped out, badge clipped discreetly to his belt. He did not approach yet. He observed. The sergeant asked the woman if she required medical attention. She said she was fine. He apologized for the delay. The word hung heavy. The first officer bristled. He reminded the sergeant of protocol, of officer discretion. The sergeant reminded him of proportionality. He asked the first officer to step aside. The officer complied reluctantly, voice rising as he protested. The sergeant instructed the younger officer to secure the scene and take statements from witnesses. The crowd murmured, sensing the shift. This was no longer containment. It was review. The sergeant addressed the crowd briefly, assuring them the situation was under control. He asked for cooperation. The phones kept recording. Accountability had its own momentum now. He returned the identification to the woman with both hands. He addressed her formally, using her title for the first time. The first officer froze. The name moved through the crowd in whispers, then certainty. A circuit judge. Assigned to this courthouse. Scheduled to preside that morning. The first officer stepped forward, disbelief cracking his composure. He said there must be a mistake. The sergeant corrected him. There was no mistake. The officer's authority collapsed inward, replaced by procedure. He was instructed to remove his duty belt and hand over his radio. He did so slowly, eyes darting, reality setting in. The man from the SUV approached, identifying himself as Internal Affairs. He nodded to the sergeant, then to the judge. He asked if she wished to file a complaint. She said she would consider it. Her restraint was louder than anger. The sergeant ordered the first officer to sit on the steps where the judge had knelt. The symmetry was not announced. It did not need to be. The officer sat, rain dampening his uniform, eyes fixed ahead. The crowd went silent. The younger officer stood nearby, conflicted, watching authority realign around rules it had ignored minutes earlier. The sergeant spoke into his radio, documenting, precise, careful. Every word mattered now. The judge thanked the sergeant and asked if court could proceed. He nodded, embarrassed, respectful. The bailiffs moved quickly, opening doors, clearing a path. As she walked past the first officer, she did not look at him. That absence cut deeper than confrontation. Phones captured the moment. Authority reversed without spectacle, without raised voices. Just process correcting itself. The Internal Affairs officer signaled for additional units. Consequences were no longer hypothetical. The rain stopped completely. The courthouse clock ticked forward. Inside, a courtroom filled with quiet urgency. Outside, an officer sat stripped of command, understanding too late that power borrowed without restraint is always temporary. The shift was complete now, though it moved without announcement. What had begun as a routine assertion of control had transformed into a quiet exposure, the kind that settles in slowly before striking deep. The judge entered the building not as a spectacle, but as a presence reclaimed. Doors closed behind her, sealing the courthouse from the rain, but not from consequence. Inside, the courtroom rose instinctively as she took the bench. No one needed explanation. Word had already traveled through hallways and radios, carried by lowered voices and urgent looks. The clerk called the room to order, hands steady but eyes wide. The judge adjusted her robe, expression composed, as if the morning outside had been an entirely different lifetime, yet the weight of it followed her. She paused, just briefly, allowing the silence to settle. Then she spoke, voice level, clear, filling the room without effort. Proceedings would begin shortly, she said, but first, there was a matter of record to address. Outside, the first officer remained seated on the steps, rainwater darkening the stone beneath him. Internal Affairs stood nearby, speaking in low tones, documenting every detail. His radio lay silent. His authority had not been taken by force. It had been withdrawn, cleanly, by process. Inside, the judge stated the facts without embellishment. She described being stopped, ordered, humiliated. She did not raise her voice. She did not name the officer yet. She spoke as a witness to her own treatment, using the same measured language she applied to any case before her. The courtroom listened, rapt, the air thick with recognition. She explained that the issue was not her status, but the conduct. That the harm existed regardless of who knelt on those steps. Her identity only made the failure visible. Phones were no longer needed here. The truth carried itself. The bailiff shifted uneasily. The clerk stopped typing for a moment, then resumed. Attorneys exchanged glances, understanding the gravity. This was not a delay. This was the law examining itself. The judge ordered the record to reflect the incident in full. She instructed that all footage be preserved, all reports submitted without alteration. She directed the court administrator to notify the chief judge and the oversight committee immediately. Each instruction was precise, procedural, unassailable. Outside, a supervisor approached the seated officer and informed him he was being placed on administrative leave pending investigation. The words landed with finality. He nodded numbly, staring ahead. The crowd had thinned now, but those who remained watched in silence. There was no cheering. This was not entertainment anymore. It was correction. Inside, the judge concluded her statement by reminding the room that authority exists to protect dignity, not diminish it. That compliance demanded without cause erodes trust. That justice cannot be selective. She did not moralize. She stated principle. She then signaled for the first case to be called. The courtroom moved forward, altered but intact. Justice resumed, carrying the imprint of what had just occurred. In the hallway, court staff spoke in hushed urgency. Calls were made. Emails sent. Policies pulled from binders that had not been opened in years. The incident was no longer contained. It was spreading through channels designed for exactly this purpose. Outside, the internal affairs officer finished his notes and asked the first officer to stand. He complied, legs stiff, posture diminished. He was escorted to a waiting vehicle, not in cuffs, but in consequence. The symmetry lingered unspoken. The younger officer watched from a distance, understanding now the cost of silence and the shape of responsibility. He would remember this moment longer than any training lecture. Inside her chambers, the judge removed her robe and sat alone for a moment. The quiet pressed in. She closed her eyes briefly, steadying herself. Then she reached for a pen and began to write, documenting not as a victim, but as a steward of the system. The power reveal had not come with a name shouted or a badge flashed. It had come through restraint, through record, through the law turning inward. Outside, the steps dried under a clearing sky. Inside, a system had been forced to see itself clearly. The reveal was complete. What followed would take longer. And it would matter more. The consequences unfolded with the patience of systems that had learned, over time, how to protect themselves by moving slowly. By the afternoon, official statements replaced speculation. The police department confirmed that an officer had been placed on administrative leave pending a full investigation. The wording was cautious, neutral, familiar. But the footage circulating online made neutrality impossible. Multiple angles showed the same image: a woman kneeling on courthouse steps, rain soaking through her clothes, an officer standing over her with practiced authority. View counts climbed into the millions within hours. Commentators dissected tone, posture, phrasing. Former officers weighed in. Civil rights attorneys paused their schedules. What might once have been dismissed as a misunderstanding now carried documentation, timestamps, witnesses. The department initiated an internal review, then, under pressure, announced an external one. Internal Affairs released a timeline that contradicted the initial police report. Orders that had been described as standard procedure found no support in written policy. Training manuals were quoted publicly, line by line, exposing gaps between rule and behavior. The officer was called in for questioning the following morning. He arrived early, uniform replaced by a pressed civilian jacket, posture stiff. Investigators asked him to recount events in detail. Each answer was compared against video, audio, witness statements. His justifications narrowed as contradictions surfaced. Safety concerns. Suspicion. Officer discretion. None explained the kneeling order. None explained the duration. None explained the refusal to clarify detention status. The younger officer was interviewed next. His account was careful, factual, restrained. He described discomfort. He described uncertainty. He described asking questions that went unanswered. His testimony did not accuse. It corroborated. Supervisors were questioned about response times and oversight. Why no immediate intervention? Why courthouse security had not been consulted? Why a sergeant had not been dispatched sooner? Each why revealed another delay, another assumption that the situation would resolve itself without scrutiny. The judge declined media interviews. Instead, she submitted a formal complaint through the proper channel, accompanied by a sworn statement. Her language was clinical, precise, devastating. She detailed the physical conditions, the public exposure, the misuse of authority. She referenced statutes, departmental policy, constitutional principles. Her complaint did not demand punishment. It demanded accountability. Civil rights organizations filed notice of intent to observe the investigation. The city attorney's office requested access to footage. The police union released a statement urging patience and due process, then quietly reassigned its spokesperson when the tone drew criticism. Within a week, the officer's administrative leave became unpaid suspension. The announcement cited preliminary findings of policy violations. Failure to de-escalate. Improper detention. Conduct unbecoming. Each phrase carried weight. Each narrowed the path back. Community forums filled auditoriums. Residents spoke calmly but firmly about patterns, not incidents. About humiliation as control. About dignity as expectation. The footage played silently on screens behind them, looping, undeniable. The department announced mandatory retraining for officers assigned to courthouse detail. The announcement was meant to signal reform, but it also acknowledged failure. Supervisors were reassigned. A commander was placed under review for oversight lapses. Legal filings followed. A civil complaint named the officer, the department, and the city, not for spectacle, but for remedy. The judge recused herself from any related proceedings, citing ethics. Another judge was assigned. Process held. The officer's disciplinary hearing took place behind closed doors, but outcomes could not be hidden. He was found in violation of multiple policies. His badge was revoked. Termination followed, formal and final. The announcement was brief. The impact was not. Appeals were filed. They failed. Arbitration upheld the decision, citing overwhelming evidence. The footage had done what testimony alone often could not. It had removed doubt. The younger officer requested a transfer. he cited professional development. It was granted. He enrolled in additional training voluntarily, later speaking at an internal seminar about intervention and responsibility. His remarks were not publicized, but they spread. The department released a revised use of authority directive, explicitly prohibiting humiliation-based commands absent clear, articulable threat. The language was new. The necessity was old. Outside the courthouse, a small plaque was installed months later, marking the steps as a public space governed by constitutional protection. It was understated, easy to miss. That was intentional. The judge returned to the bench without ceremony. Her rulings remained steady, her demeanor unchanged. She did not reference the incident again in open court. She did not need to. The system had recorded it. Trust did not restore itself overnight. It rarely does. But something had shifted. Officers hesitated longer before issuing commands. Supervisors intervened sooner. Phones still came out, but now so did explanations. The consequences were not revenge. They were record, review, removal, reform. Slow. Procedural. Lasting. The reform did not arrive as a single announcement. It accumulated through memos, revisions, quiet meetings, and uncomfortable acknowledgments that the incident had revealed something structural, not accidental. City officials convened a joint review panel that included judicial representatives, police leadership, civil rights advisors, and courthouse security administrators. The mandate was narrow in language but broad in implication: examine how authority was exercised on courthouse grounds, and why existing safeguards had failed. The panel's findings were delivered without flourish. They identified overlapping jurisdictions that blurred responsibility, training that emphasized command presence without equal emphasis on restraint, and a reporting culture that deferred scrutiny until after public pressure forced it. None of this was new. What was new was the evidence that made denial impossible. Courthouse protocols were rewritten. Jurisdictional boundaries were clarified in writing, eliminating assumptions about who controlled what space. Officers assigned to judicial facilities were required to complete specialized certification focused on constitutional protections, de-escalation in symbolic civic spaces, and the unique vulnerability of public humiliation. Completion was not optional. Assignment became contingent. Supervisory structure changed. A dedicated courthouse oversight lieutenant position was created, with direct reporting obligations to both the police department and the court administrator. The role existed to interrupt exactly what had happened: unchecked discretion exercised in isolation. For the first time, shared accountability was formalized rather than implied. Body camera policy was amended to require activation for all citizen encounters on courthouse grounds, without exception. Failure to activate now triggered automatic review, not discretionary inquiry. The change was technical, but its effect was cultural. Officers adjusted behavior when certainty of record replaced assumption of narrative control. Training academies incorporated the footage into curriculum, anonymized only in name. Recruits watched silently as instructors paused the video at key moments, not to dramatize, but to ask precise questions. What was the lawful basis here? What alternatives existed? At what point did authority become excess? The answers were not rhetorical. They were graded. Judicial conferences addressed the incident indirectly, framing it as a reminder of visibility. Judges discussed access points, staff coordination, and how easily the symbol of justice could be undermined at its threshold. Security procedures were standardized across circuits, reducing reliance on individual discretion. Community oversight boards were granted expanded access to internal data on use of authority complaints tied to public facilities. Patterns that had once been buried in aggregate reports were separated, tracked, and published quarterly. Transparency became procedural rather than reactive. The department revised its disciplinary matrix, increasing penalties for humiliation-based conduct, even absent physical force. The language mattered. Harm was no longer defined only by injury, but by degradation. This reframing altered how cases were evaluated, how reports were written, how supervisors intervened. No single reform promised transformation. None claimed to end misconduct. But together, they changed incentives. They shortened the distance between action and consequence. They replaced ambiguity with instruction. The judge did not sit on the reform panel. She was consulted only once, briefly, offering no commentary beyond confirming factual accuracy. Her absence reinforced the point. Reform was not a favor granted to her. It was a responsibility owed to the public. Months later, an internal audit showed a measurable decline in complaints related to courthouse interactions. More telling was the increase in early supervisory intervention reports, instances where officers corrected peers before escalation. These moments did not trend online. They were not dramatic. They were effective. The steps outside the courthouse remained unchanged, stone-worn smooth by time. People still passed through daily, unnoticed, unremarkable. That was the goal. Justice functioning without spectacle, the system had not redeemed itself through apology or promise. It had adjusted, slowly, deliberately, under pressure it could not ignore. The incident became a case study, then a policy reference, then part of institutional memory. Reform, in the end, did not erase what had happened. It ensured that what had been exposed could not be easily repeated, at least not in the same way, not without record, not without response. The story did not end with a ruling or a policy memo. It settled instead into memory, carried quietly by those who had witnessed it and those who would never know her name. The courthouse returned to its rhythm. Footsteps echoed. Doors opened and closed. Justice moved forward without acknowledging how close it had come to contradicting itself. The judge resumed her work with the same discipline she had always shown. She listened carefully. She ruled narrowly. She protected the record. To observers, nothing had changed. That was intentional. Authority, when exercised correctly, does not demand attention, yet for many who had seen the footage, something had shifted. The image of a woman kneeling where justice was meant to stand did not fade easily. It lingered as a reminder that systems do not fail loudly at first. They fail quietly, through small permissions granted to arrogance, through silence mistaken for order. The officer's absence eventually became unremarkable. Another uniform filled the space. Another face took the post. But the rules governing that space were no longer assumed. They were known. They were written. They were enforced. The younger officer carried the lesson forward in ways no report could capture. He spoke up sooner. He asked harder questions. He understood that loyalty to the law sometimes meant interrupting those who wore it. For the public, the incident became something rarer than outrage. It became evidence. Proof that calm insistence on accountability could bend institutions without breaking them. Proof that justice did not require spectacle to correct itself, only exposure and patience. The steps outside the courthouse remained what they had always been, stone, worn smooth by time. But for those who knew, they marked a boundary. A reminder that dignity does not belong to rank, and authority does not excuse its removal. This story is not about knowing who she was. It is about knowing who anyone could be when systems forget themselves. It is about recognizing injustice not only when it shouts, but when it speaks politely, wrapped in procedure. If you believe accountability matters even when no one powerful is watching, stay alert. If you believe dignity should never be conditional, remember this moment. Justice holds only when it is held to its own standard.